Welcome back to the deep dive. Today is a really special one for you, the learner. If you are currently in the trenches studying for your professional planning exams.
Or even if you're just trying to keep your designation in good standing.
Exactly. You probably know that the code of conduct can feel a bit abstract. It's basically this list of thou shalt nots that you memorize and just kind of hope you never have to think about too hard.
Yeah, and that's a very common trap. We tend to treat ethics like a checklist. But in the real world, ethics is messy. It's about gray areas, power dynamics, and the collision of different roles.
Right. And today we are taking a microscope to a very specific real-world collision. We are breaking down a disciplinary decision from the Ontario Professional Planners Institute, the OPPI.
Specifically, the discipline committee decision that was handed down on November 26, 2021.
And for anyone prepping for an exam, this document is absolute gold because it's not a hypothetical scenario. It actually happened. There's real drama here.
It's definitely dramatic, but more importantly, it serves as a really critical precedent. It deals with a situation that I think tempts a lot of senior planners. We are talking about the two hats dilemma.
The two hats dilemma.
Right. What happens when a registered professional planner, an RPP, decides to run for office and becomes an elected official? Can you wear both hats at the very same time?
Spoiler alert, for everyone listening in this particular case, trying to wear both hats resulted in a career-ending disaster. So to help you structure your study notes, we're going to organize this deep dive exactly how the source document is laid out.
That makes the most sense. It mirrors the logical flow of the actual hearing.
Yeah. So we'll start with the order, which gives us the context of, who was there and what legal mechanism was used. Then we will get into the really juicy part, the allegations in Appendix A.
That would be the what happened part of the document.
Exactly. After that, we'll look at the resolution in Appendix B, and finally, we'll cover the committee's reasoning, why they decided this outcome protects the public.
It's a great structure. The setup, the bad behavior, the deal, and the logic.
I really like the bad behavior. Let's actually put a pin in that and start with the setup. Set the scene for us. It's November 2021. I assume we're on Zoom?
Correct. This is detailed in the reasons for order section. The hearing took place via video conference. The decision-making body, the tribunal, was the discipline committee.
And who was sitting on that panel?
It was made up of 3 fellow RPPs. Wendy Knott was the chair, and she was joined by Sue Cumming and Matt Pearson.
Okay, so a panel of peers, that is pretty standard. And who were the actual parties involved in the dispute?
On one side, you had the OPPI, who were represented by their independent legal counsel. On the other side, you had the member.
The person accused.
Right. Now, in the public version of this document, the name is blacked out, it's redacted, so we will just refer to them as the member. But here is the first major twist of the case. The member did not attend the hearing. They were unrepresented and completely absent.
Wait, they just pulled a no-show.
Not exactly. They didn't attend, but this was completely prearranged. You see, the OPPI wasn't there to conduct a full trial that day. There were no witnesses, no cross-examinations.
And what were they doing?
They were there to bring a motion to stay the proceedings.
Okay, let's unpack that term immediately, because for the planners listening who aren't lawyers, what exactly is a motion to stay? Is that like dismissing the case?
No, and that distinction is absolutely crucial for understanding administrative law. A stay is essentially a pause button.
A pause button.
Exactly. It suspends the legal proceedings, the charges are not dropped, and the file is not closed. It's just frozen in time.
Okay, but why do that? Why not just finish the hearing?
A stay is usually granted when the 2 parties have reached a settlement agreement outside of the hearing room. The regulator basically says, okay, we have what we need, so we don't need to go through the expensive formality of a full trial right now. We will pause the prosecution.
But the threat is still there.
The threat absolutely remains. If the accused breaks the conditions of their agreement, the pause button is released, and the prosecution resumes exactly where it left off.
Got it. So the Mengran didn't show up because the deal was already signed and sealed. But to understand why a deal was even necessary, we have to look at what they were accused of in the first place.
Right. Which brings us to Section 2 of our deep dive Appendix A, the Statement of Allegations.
This is the section that really serves as a cautionary tale. If you are studying for your exam right now, pay close attention here.
Definitely. This connects directly to the professional code of practice, specifically regarding how you treat colleagues and how you manage conflicts of interest.
So let's look at the member's profile. From the document, they weren't exactly a rookie, were they?
Far from it. The document states the member had been a registered professional planner since 1994.
Wow.
Yeah. That is nearly 30 years of experience. They were a veteran in the field.
But the trouble started when they entered the political arena.
Exactly. From 2014 to 2018, this member served as an elected councilor in their municipality, and then in 2018, they actually ran for mayor.
Now, generally speaking, we encourage planners to get involved in their communities. Civic engagement is good, but once you are elected to office, your role changes fundamentally.
It does. And this particular municipality had a very specific policy called the Council Staff Relations Policy.
What did that entail?
It's a pretty standard governance model. Council sets the policy direction, and staff provides the technical, professional advice to support that direction. The policy explicitly stated that elected councilors were not to provide technical expertise or act in their professional capacity.
Basically, stay in your lane.
Stay in your lane. You are there to represent the voters, not to be the city planner.
Yeah.
But the allegations suggest this member completely refused to take off their planner hat.
They wanted to be both the decision maker and the expert.
Exactly.
Let's get into the specific examples listed in the allegations, because reading through them, some of these behaviors are pretty shocking for a professional environment.
They really are. Let's start with how they treated other professionals. The allegations cite a clear breach of the code of practice regarding professional respect.
The consultant issue.
Right. The member allegedly referred to reports prepared by external environmental or ecological consultants as negligent, quite deficient, or not up to standard.
Whoa. Using the word negligent in a public council meeting, that is not just a casual criticism, that is a heavy legal accusation.
It is incredibly heavy-handed. As an RPP, you have a duty to treat colleagues, and that absolutely includes external consultants with respect.
You can disagree with them.
Of course, you can disagree with their findings, you can ask tough questions about their methodology, that is part of the job, but to publicly label their work as negligent without a formal review process,
It undermines public trust.
it undermines the trust in the entire consulting profession. It implies, I know better than you because I've been a planner since '94.
Yeah, using their RPP status to essentially bully the consultants. And it didn't stop with consultants either.
No, it didn't. The allegations detail how the member attempted to circumvent the municipal planning staff entirely.
Right. Paragraph 4.
Yes, paragraph 4 mentions that the member provided a detailed discussion paper containing their own analysis and recommendations on a planning issue.
While the actual staff were still working on it.
Exactly. While the staff were still conducting their formal review, the member, who again is the sitting councilor, effectively wrote a shadow report.
That is wild. They were bypassing the staff and saying to the rest of council, here's my professional opinion on this matter.
And that puts the actual staff in an impossible position. Think about it. If the expert counselor says one thing and the staff planner says another, who does the rest of the council believe?
That creates total chaos.
Yeah.
And reading further, the member went even further than just writing reports.
Yes. The allegations state they conducted their own independent reviews. They were contacting a planner at the Ministry of Municipal Affairs and the planning director directly, entirely outside of the formal council process.
Acting like a one-person planning department.
Right. And paragraph 4, subsection E says this gave the impression that they were acting as an independent expert, which leads us to the absolute core violation here.
The conflict of interest. The two hats problem.
The two hats. The member was running for mayor. They relied on constituents' votes to keep their job, and those constituents knew that the member was an RPP.
So the voters, and probably other councilors too, just assume, well, he's an RPP, so his opinion is the objective professional truth.
Correct. But he was not being objective. He was a politician advocating for a specific outcome that would please his voter base. Paragraph 10 of Appendix A sums it up perfectly. It says the member was leveraging their credentials as an RPP to advocate for a specific policy interpretation or to influence planning decisions.
And the charge is that the member failed to explicitly state that they were not acting as an RPP giving independent advice.
Precisely. That is the key takeaway for anyone studying for the exam. You cannot weaponize your professional designation to win a political argument.
Because the code of practice demands objectivity.
Exactly. If you are advocating for a political goal, you have lost that objectivity. Therefore, you cannot speak as an RPP on that matter.
You have to declare the conflict.
You must declare the conflict and step back from the professional role entirely. This member tried to use the prestige of the license to bolster their political power instead.
So looking at Appendix A, the evidence seems pretty overwhelming. Undermining colleagues, bypassing staff, misleading the public about their role. It looks like an absolute slam dunk for the prosecution.
It does.
But, as we established earlier, there was no trial. Which brings us to Section 3 of our deep dive, the resolution. Or, as it is titled in the source material, Appendix B.
The undertaking, agreement, and acknowledgement.
Right. This was signed on October 5, 2021, which was about 6 weeks before the hearing took place.
Huh.
What exactly did the member agree to?
It was essentially a total surrender of their professional identity. Paragraph 1 states the member agrees to resign their membership in OPPI permanently, effective December 31st, 2021.
Okay, so they are out.
They are out. And paragraph 2 says they irrevocably surrender their certificate of registration.
Irrevocably. No takebacks.
No takebacks ever. It goes further. Paragraph 2 also explicitly states they will not be entitled in the future to seek membership in OPP. It is a permanent, lifelong ban.
What about the title itself? Can they still put RPP on a business card? Maybe add an asterisk that says former?
Definitely not. Paragraph 3 is extremely strict about this. They must strictly cease using the title Registered Professional Planner, the abbreviation RPP, or implying in any way that they are a member.
So they can't even hold themselves out as a retired member?
No,
Yeah.
they are completely erased from the register. And paragraph 5 authorizes OPPI to publish a summary of this decision in their annual report and in Y Magazine.
They wanted full transparency.
They wanted the entire profession to know that this specific conduct resulted in immediate removal.
And here is the twist. The part where it gets really interesting and maybe a little confusing for people outside the legal world.
The no admission clause.
Yes. I was reading the whereas clauses in Appendix B, and I found a sentence that seems to contradict everything we just discussed. The member states, I do not make any admissions that I committed acts of professional misconduct.
It is a very classic legal maneuver.
But how does that even work? I agree to quit forever, hand over my license, and never call myself a planner again, but I didn't do anything wrong.
It sounds totally paradoxical, I know, but it is actually very pragmatic for both sides. By including this clause, the member avoids having a formal guilty verdict on their public record.
Why does that matter if they're losing their license anyway?
It can be incredibly important for protecting themselves against civil lawsuits, or, since this person is a politician, protecting their reputation with their voters.
Oh, I see. They can spin it.
Exactly. They can go to the press and say, I chose to resign my membership so I could fully focus on my political career and serving my constituents, rather than, I was kicked out by my peers for professional misconduct.
It allows them to save face, personally and politically.
Yes. And for the OPPI, as the regulator, they do not necessarily care about extracting a confession. They care about the outcome.
Which transitions us perfectly to the committee's reasoning. This is Section 4 of our deep dive, the reasons for order. Why did the committee accept this no admission deal instead of forcing a trial to prove the member was guilty?
The committee explains their logic clearly in paragraphs 8 through 17. They applied what is known as a public interest test.
Meaning what exactly?
Essentially, the panel asked themselves, if we accept this settlement deal, is the public adequately protected?
And their conclusion was yes.
Yes, for 3 very specific reasons that you should definitely note for the exam. First is protection. Paragraph 12 states that the member's permanent resignation and their undertaking not to reapply will protect the public interest.
That makes total sense. If the person is no longer a planner and can never call themselves a planner, they can no longer commit professional misconduct as a planner.
Exactly. The danger to the public is neutralized. The second reason is resources.
Money and time.
Yes. Paragraph 15 notes that the profession and the public will also avoid the significant costs of a full hearing.
Because disciplinary hearings are expensive.
Incredibly expensive. You have the independent legal fees for OPPI, the time and expenses of the panel members, the administrative overhead, and remember, all of that is paid for by the membership dues of other RPPs.
Right.
So if OPI can achieve the ultimate penalty, permanently removing the member without spending tens of thousands of dollars on a contested hearing, that is a highly responsible use of resources.
That is a very practical, real-killed point. What was the third reason?
Confidence. Paragraph 16 says the resolution is consistent with the public interest and ensures that it will not undermine the public's confidence in OPPI as a regulator.
Translation, we need to show that we take these allegations incredibly seriously. Even without a formal guilty verdict, the fact that this person is gone forever sends a very strong message.
Correct. It proves that OPPI is not a paper tiger. If you blatantly violate the code, you will be removed from the profession.
Now, I have to jump back to the motion to save for a second. We established that the prosecution is just paused. What happens if this former member decides to break the rules of the deal? Let's say next year, they run for office again, and accidentally put RPP on their campaign website.
That is exactly where the trap snaps shut. Paragraph 11 of the reasons document explicitly says that should the member breach or fail to comply with any term of the undertaking, the stay may be lifted
So the pause button is released.
immediately. OPI can instantly revive all the allegations in Appendix A, all the stuff about negligence and shadow reports, and proceed with the prosecution. They can drag the member right back to a hearing.
It really is like a sword of Damocles hanging over their head.
That is a perfect metaphor. The member is free to go, provided they never, ever pretend to be a planner again. The very moment they slip up, the deal is completely off.
Wow. So let's bring this all home for the listener. We have gone through the document top to bottom. The context of the hearing, the specific allegations of crossing the line between staff and counsel, the resignation deal, and the committee's reasoning.
It's a lot to digest.
It is. So if you were sitting in that exam hall and a question comes up about political involvement in professional duties, what is the ultimate golden rule here?
The golden rule is that your professional obligations do not vanish just because you step into a political arena. That council-staff relations policy we discussed isn't just a gentle suggestion, it is a necessary safeguard.
The separation of roles.
Exactly. The key takeaway is about maintaining that separation. If you are an RPP, you are trained to be objective, to follow evidence, and to respect the process. If you are an elected official, you are an advocate for your voters. This case teaches us that you absolutely cannot use the authority of the first role to bolster the advocacy of the second role.
You can't have it both ways. You cannot claim the objective prestige of the expert while actively playing the partisan game of the politician.
Precisely. And if you do decide to enter politics, you need to be hyper-vigilant. You must make it abundantly clear when you are speaking as a counselor representing a ward and explicitly state you are not providing professional planning advice.
Which this member failed to do.
They failed entirely. They blurred the lines and it cost them their credential permanently.
It is a really sobering lesson. It highlights that being an RPP is not just a job title you clock out of at 5 o'clock. It is a strict standard of behavior that follows you everywhere, even into the mayor's race.
And just a quick tip for the exam, make sure you reference the specific concepts we covered today. This entire decision rests on.
Well, this has been an incredibly enlightening look at a document that, at first glance, just looks like a bunch of dry legalese. But underneath, it really is a very human story about ambition, roles, and boundaries.
And consequences. Above all, it's a story about consequences.
Before we sign off today, I want to leave you with a final thought to mull over. We have seen that this member effectively had to choose, be a politician or be a planner. They couldn't be both on the same files.
Right.
My question to you is this. If a professional planner enters politics, is it ever truly possible to separate their expertise from their political identity? Or does this case suggest that the two roles are just fundamentally incompatible when it comes to specific development issues?
That is the ultimate question. Can you know too much to be a good politician?
Definitely something to think about. Thank you for joining us on this deep dive. Make sure to check Part 3 of Appendix I to Bylaw Number 1 regarding the Professional Code of Practice before your exam. Good luck studying.
Good luck, everyone. Keep analyzing those gray areas.